And we are recording.
Okay, great. Let's call the meeting to order. Sunshine Ordinance Task Force, May 5th of 4:01. Cheryl, take it away.
Hang on a second. Remote access to information and participation. In accordance with Governor Newsom's Executive Order N3320 declaring a state of emergency regarding the COVID-19 outbreak, and Mayor London N. Breed's proclamation declaring a local emergency issued on February 25th, 2020, including the guidance for gatherings issued by the San Francisco Department of Public Health officer, aggressive directives were issued to reduce the spread of COVID-19. On March 17, 2020, the Board of Supervisors authorized their board and committee meetings to convene remotely via Microsoft Teams and will allow remote public comment via teleconference. Members of the public may participate by phone or may submit their comments by email to cheryl.leger@sfgov.org. All comments received will be made a part of the official record. Sunshine Ordinance Task Force agendas and their associated documents are available at sfbos.org/sunshine. Shall I do the vote, the sequence here, the attendance?
No, you have one more sentence and then I have to do
You're
meeting.
right. See, yep. As the COVID-19 disease progresses, please visit the Sunshine Ordinance Task Force website regularly to be updated on the current situation as it affects the legislative process.
Meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and or menacing behavior may be asked to leave. I'm going to add that if there is any offensive language that any of the task force members might experience, they can call for meeting decorum, and we will deal with it at that time. This will allow for a disruption during any public testimony. Period. Thank you. Okay, item number one.
Number one, call to order, roll call, and agenda changing. Roll call. Chair Wolf?
Aye, here.
Chair Wolf present. Kai Forsley?
Here.
Kai Forsley present. Laurie Jones Neighbors?
Present.
Laurie Jones Neighbors present. Chris Highland?
Present.
Chris Highland present. Matthew Yankee?
Present.
Matthew Yankee present. Laura Stein? Laura Stein? Laura Stein not present. Jennifer Wong?
Present.
Jennifer Wong present. Jaya Padmanabhan?
Present.
Jaya Padmanabhan present. Kevin Frazier?
Present.
Kevin Frazier present. Lila LaHood?
Present.
Lila LaHood present. Dean Schmidt?
Present.
Dean Schmidt present. We have a quorum.
Okay, thank you. Any changes or adjustments to the agenda?
I just want to mention Laura Stein is present.
Oh, you are? Oh, okay, great. Thank you. I didn't hear you.
That's all right.
Okay. Agenda changes. I know of one. Item 8, file number 20092. Yesterday at about 3:30 in the afternoon, I received an email from Carl Kramer, who said that he had received all his records from the Department of Recreation and Parks and wished to withdraw his complaint.
Great.
Okay, thank you.
And then this afternoon, about a half hour ago, I got an email from, I was CC'd on an email from Mr. Andrews. His case number is 20079. He said that he is inclined to accept the district attorney's response and take today's hearing off calendar. So perhaps we should ask if, when that case comes up, if Mr. Andrews and the respondent are here today, because I got this email at 3:17 today.
Well, why don't we deal with that now if either of the parties are here and we can dispense with it, we'll at least know whether it's going to happen or not. So is either of the parties here?
Mr. Andres, this is Shane Andres for Tom Mosley. I am here.
Okay, and what is the status of this file at this point?
So just to elaborate, yes, I had sent an email to Ms. Burke of the District Attorney's Office because I had received a letter from her yesterday just confirming what she had done with respect to searching for documents in response to our request, essentially just reiterating the previous response of
We just need,
documents.
Mr. Andres, we just need to know whether we're going to be hearing the case tonight or not, or whether you're going to pull it.
Yeah, no, you're right. I'm sorry. The point being is, I said if I would pull it, if she could confirm one or two things, and I haven't received an email response. So as of now, unless she's here and wants to jump on and confirm, then I would say that I still need to go forward, I guess.
Okay, is there a representative from the District Attorney's Office present? Calling for a representative from the District Attorney's Office. Okay, hearing none, then we'll ask again sometime during the meeting before the item comes up, and we'll deal with it then. Any other changes to the agenda?
As far as I know, those are the only two changes that came up.
Okay, members, any changes? Adjustments, corrections? Okay, hearing none, let's move on. Please call next item, Mr. Leger.
Okay. Item number 2, approval of the minutes from the Sunshine Task Force Rules Committee of September 24, 2019.
Any changes or adjustments, edits to the minutes?
This is Vice Chair Yankee. I have just a couple here.
Okay. Matthew, hang on so I can follow what you're saying.
Sure. Let me know when you're ready, Cheryl.
Okay, I have the minutes in front of me. What's your comment?
Okay, so I think that Fiona Hinsey, me, and Chris Highland were the ones scheduled to be there, but I believe Member LaHood and Chair Wolf joined us as well. So I noticed Member LaHood is listed in the roll call, but Chair Wolf is not. I don't know if we ordinarily list additional members who joined who aren't normally part of the committee in that section or not. If we do, we should probably list both of them since they were both present. And then the second correction was on the motion to the meeting minutes. Just the 3 of us voted, but you have the ayes as 4.
Oh, 3. Right. Very good point.
So those are the 2 things.
Any other changes or adjustments to the minutes? Okay, hearing none. For before I take the let's get a motion on the floor.
Sure, I'll go ahead and move to approve the minutes with those changes.
I'll second. This is Lila,
Please.
Member LaHood.
Okay, so moved by Vice Chair Yankee, second by Member LaHood. Please, for open public comment, please.
Are you taking public comment now?
I just announced public. Yes, I announced public comment.
Give us a moment. I think we're waiting for Cheryl to get back online. She might be having some issues.
Mr. Warfield, is that you?
Yeah,
Yes.
Cheryl, you can go ahead and take public comment if you're ready to time it.
Yeah, I just had to go get my timer. That was it.
Okay.
Are you ready, Mr. Warfield?
I think I am. Thank you. Yes. Tell me when to start.
Go ahead.
Hi, this is Peter Warfield, Executive Director of Library Users Association. And I say these things because in a normal meeting, people could see each other, people would know who is speaking, could come up to me, or I could go up to them and identify, exchange information about contact and so on. As it is here, I don't even know who is attending or if there's anybody attending other than the members. So I give the contact information, which is libraryusers2004@yahoo.com, and by mail, P.O. Box 170544, San Francisco, California, 94117. Thank you very much for providing these minutes. I just have a few questions about that process, and that is, it seems a very long time since these since the meeting occurred, and so I'm wondering why it looks like about 1.5 years. I guess I understood somewhere along the way, and I can't quite say where, don't recall exactly, but it seems as though I understood that if minutes are not approved by the committee that had the meeting, and I thought I heard something like 6 months, then it would come to the full task force. So this is quite a lot longer than 6 months. I'm wondering if there is a procedure and how that's working. I'm curious about something I've seen occasionally that I don't recall seeing before, and that is at the end of the meeting minutes, it talks about, it says NB, and says that the chronological sequence may not be the same in the minutes as what actually happened. So I'm not sure why that says that. It doesn't see. It seems to confuse kind of the issue, and also if somebody wants to listen to the recording, they might have trouble finding what's going on if the minutes don't reflect what the sequence was of the actual meeting. I've also noticed in some minutes a very helpful thing, which is timing notes that show when in the recording a certain item
30 seconds, sir.
Thank you. That shows when the item is on the recording, 38 minutes in until 1 hour and 5 minutes out, and so on and so forth. So I'm wondering what your procedure is for that. These minutes don't seem to have any of those timing notes that are key to the recording. Thanks very much.
Is there another public commenter?
Any other public comment for the minutes? Okay, hearing none. We ready for a vote? Please call the roll.
Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Frazier?
Aye.
Member Frazier, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein?
Aye.
Member Stein, aye. Member Forsley?
Aye.
Member Forsley, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member Hyland?
Aye.
Member Hyland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to approve the minutes, the roll committee minutes of September 24, 2019 has passed.
Okay, thank you. Please call the next item.
Approval of the minutes from the Sunshine Ordinance Task Force April 7, 2021 meeting. I have a copy of those minutes. Does anybody have any changes?
Any changes or adjustments to the minutes? This is for the meeting of April 7th.
Do we want really small changes, like just misspellings or things like that?
Yes.
Mm-hmm.
Okay, then I can give a few. On page 9, under number 2, third line, it says Member Stein request. Should be requested.
Wait a minute. What number is it? Item 2, item 3?
Item 2, third line down. Just requested.
Comment on previous action / requested correction?
Sorry, I'm looking at P9, which is actually on the 3rd page.
I know, I understand you're looking at P9, but I don't have that up. I have my notes up and I have a copy of the minutes.
Approval, it's number 2, approval of minutes from the
Page-
Sunshine Ordinance
Page
Task Force.
2.
Page 3 on the file, on the PDF.
Item 2. Could you read that language again, please? I'm sorry, I'm taking so much time trying to find
Okay,
it.
are you on page 3 of the PDF?
I'm looking at a hard copy of the minutes. I printed it out and that's what I'm looking at. I'm not
Okay.
looking for anything on a computer.
Okay, then I guess it's page 2 of the minutes if you don't count the cover sheet.
Yeah.
And it's item 2, 3rd line down.
Member Stein requested that the question mark
Yeah,
be
requested instead of request.
Okay.
And then similar thing on page 3 of the hard copy, I think, under item 3,
Okay.
7 lines down, starting with member LaHood,
Yeah.
would be provided. And then page 4,
Okay.
it says, the first line says SOTF referenced section 67.31 in urger of the mayor. I don't know what that is actually supposed to say.
I think it's supposed to say to urge.
Oh.
R is supposed to be there.
And then just for the sake of it, item 5 on that same page, 6 lines down, Ann Turbo noted the passing of, it should just say Lawrence Ferlinghetti.
F isn't, oh, F not P?
No, it's F-E-R.
Yeah, I got it.
L.
Yeah, I get it.
Okay. Then the next page, which is page 5 of the hard copy. Ooh. Second paragraph. 6 lines down. Just something's funky in there. Was out of the office with appropriated out of office information provided. I guess with appropriate out of office information provided. I don't know, maybe I should submit these later. There were just so many, well, actually there's just a few more, I guess.
Just go ahead and tell me and I'll fix them.
Okay, and then on the next page, which is, I think page, where is it?
Page 6.
Item 7, in the paragraphs that starts with action in bold.
Yeah, that's the action.
Yeah, it should just say did not violate, not did not violated. And then under item 8 on that page, the 4th line down, I think it should say by failing to provide instead of failing to aid. And then
Wait a minute. It says failing to provide. Oh, I see. Failing to. Fix the word. I see it.
Okay. And then the line after that, it says failing to keep withhold. I guess that's failing to keep withholding.
Holding, yep.
And then the next line after that, again, by failing, it should say by failing to provide, not by failing by provide. And those were the ones I caught.
Okay. I will make the corrections tomorrow morning. Repost them. Thank you very much.
Sure.
Any other changes or adjustments to the minutes of April 7th? Okay, hearing none, is there a motion to approve the minutes? And then we'll call for public comment for anything else.
Member Highland, I'll make a motion to approve with amendments.
Member Frazier, I'll second.
Moved by Member Highland, second by Member Frazier to approve the minutes with the current edits. Let's open it up for public comment, see if there are any more.
Yep. Am I muted or?
Hold on, wait for Ms. Leger to call. She may not be ready.
Mr. Warfield, are you ready now?
Yes.
Go ahead, sir.
Yes, this is Peter Warfield, Executive Director of Library Users Association. And we can be reached at libraryusers2004@yahoo.com and also by postal service at P.O. Box 170544, San Francisco, California 94117-0544. Excuse me. I think at a previous meeting I talked about the importance of name and people being recognized and people being seen when they are particularly wishing to be recognized. And so first of all, I appreciate that on these minutes, it looks like the affiliation with Library Users Association has, on the whole, been made when I have spoken. But there has not been a single contact information included, even though I believe I spoke the contact information at every time that I did speak. I'm sorry, I can't hear. What?
Can everybody please mute?
I beg your pardon?
Just hold on a second. Please hold the clock. Can everyone please mute? Member Schmidt, can you mute, please? Thank you. Okay, please continue, speaker.
So how much time do I have left, please?
Mr. Leger?
Sorry, it's muted. 1 minute, 29 seconds.
So I have a minute and a half left, right?
Correct.
Correct.
Thank you. So as I was saying, identification, people say his name, say her name, and so on. As I have said, the ability to have a public presence, to be seen, to be heard, to be able to approach people, to be able to be approached, is not there on the remote meeting. And so I would appreciate having the full identity included, which is to say Executive Director, Library Users Association, and the contact informations. With respect to the content, I am glad that you took the time to take the details from, I guess, Ms. Stein. And I would appreciate if you would do the same with my
30
suggestions.
seconds.
And so the first thing to be said is on item 2, it says, it was noted, and then there's that Peter Warfield commented, and something or another should be corrected. Well, who noted it, and how is it supposed to be corrected? Item 8 also lacks some specifics that I think would be useful to include. And again, the timing notes are not in. It would be great to have those. And I don't know if the NB note is at the end, but I don't know if it's there. I don't know what it means, but the timing notes would be useful. Thank you.
Next speaker.
Anonymous, please.
You ready, sir?
I am.
Go ahead, sir.
Thank you very much. I would like to thank the member for pointing out all the detailed corrections. It's actually, I think it's really useful because, of course, these minutes get copied into your orders of determination, and by and large, your orders of determination are the kind of the output work product of this task force. And for that reason, I would ask that you add a little bit more detail in both files 19124 and file 20066. It's not clear what the cases are about just by reading the summary. And so I would ask that you add into the sentence, Anonymous stated that police department procedures of redacting and producing documents were incorrect. Just the phrase redacting and producing SB 1421 documents were incorrect, so that someone knows what this was about if they read the order of determination later. And I would also ask that you add in file number 20066, it just says Anonymous provided various code references and explanations in support of their argument. But what argument does it mention? So I would ask it to say Anonymous provided various code references and explanations in support of their argument that the police commission cannot cite Penal Code 832.7 B6, since that's what the case was about, and that's what you decided. I understand that people say, well, Anonymous and the SFPD and the police commission were there. They already know who won and lost what. But to me, at least the reason I bring these complaints is to have written determinations of what is and isn't allowable under the Sunshine Ordinance that people after me can then use to make sure they get the records that they are owed. And so I'd ask that you add these details so people can look at your orders of determination and know what, why or what were these cases about. Thank you.
Next speaker. Okay, I just want to ask the last speaker with regards to the minutes versus the orders of determination. Are you saying that's the same verbiage?
Would you like me to respond?
I do.
From my own orders of determination, what it appears is that these summaries get copied and pasted into the orders of determination. At least that's my understanding.
Okay, so I will be more diligent to review that. But just for the minutes, because all our meetings are recorded, any further details can be found on the recordings. I do understand what you're asking for, and we'll do our best to provide at least that much substance. So it kind of, I understand it makes it a little more clear. I get that. So thank you for the response. Any other public comment on these minutes? Okay, hearing none, members. For the maker and the seconder of the motion, is there any amendments that you would like to add to your motion with regards to what the public commenters have brought forward? Or for anyone else, is there any amendments to the motion?
None here, the maker.
Okay. So we'll, we have a motion on the floor made by member Highland, second by member Frazier, with the edits that were brought forward by member Stein. No further edits are being considered at this time. Are we ready for a vote? Okay, please call the roll.
Member Highland?
Aye.
Member Highland, aye. Member Frazier?
Aye.
Member Frazier, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein?
Aye.
Member Stein, aye. Member Forsley?
Aye.
Member Forsley, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
Aye.
Member LaHood, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to approve the April 27, 2020 Sunshine Task Force meeting minutes with amendments brought by Member Stein has passed.
Thank you. I just want to announce that we'll be taking a short recess at 6 o'clock. And I'm going to do my best to try and keep our hearings to under 45 minutes. And if we hit a 45-minute mark and we haven't come to any motion for determination, then we'll deal with it at that point, whether we want to forge ahead or not. Okay, let's call the first item, the next item, number 4. Mr. Leger?
Yes. Item number 4, file number 19144, complaint filed by Anonymous against the Department of Police Accountability, Paul Henderson, Diana Rosenstein, Stephanie Wargo Wilson, and Mary Polk for allegedly violating Administrative Code Section 6721, 24, 26, and 27 by failing to respond to a public records request in a timely and or complete manner, failing to assist in a timely and or complete manner, failing to cite lawful justification for exemption, failing to key redactions by footnotes or other clear references to justifications, and failing to withhold the minimum portion of records. This complaint was heard December 20th by the Compliance and Amendments Committee. The records are found public and the matter was referred to the task force.
Okay, before we start, I'm just reading the intake form, and I just want to ask the petitioner regarding a notation that was made. Says SOTF has not heard file 19127 anonymous versus DPA et al. For merit yet. Therefore, if you have the power, I'd ask that the task force combine, not replace, this complaint into SOTF 19127 for efficiency. Is that what is happening here today, or are you going to make a request for us to do this today?
No, I believe I withdrew the other one. That one was something else, just against the same agency. All I care about is this here today. Okay,
very good. Thank you. Then let's hear from Compliance Amendments Committee Chair LaHood.
Yes.
There's anything to report on this?
This is going to be the first time that this is heard by the full task force. We found jurisdiction and that the records are public. One thing I would like to note, and I didn't mention this earlier because this wasn't about minutes, but the Compliance and Amendments Committee meeting where we heard this was December 22nd. So I know that's a minor thing, but I know as going forward, if we could.
December 22nd, okay.
Yeah.
Oh, it's just a correction in the agenda. Okay.
In the agenda, and I guess for anything going forward that might reference that. And it was just because I went to look something up and I noticed that the 20th was a Sunday.
Okay. We'll note that for the record.
I noted it. I'll make the correction.
Okay, great. Okay, Ms. Leger, if you're ready with the clock, we'll hear from, well, let me just ask, Chair LaHood, was there anything you wanted to report at a committee regarding this?
Not in particular. I think we just need to hear from the parties.
Okay, great. So let's begin. Petitioner Anonymous.
Please let me know when I may start.
You may start.
Thank you very much. Good evening, Task Force. This is an SB 1421 complaint versus the Department of Police Accountability, fairly similar to the two SB 1421 complaints you heard last month. The update as of when we had to file papers for today's meeting is on P300 or PDF page 284. So this is another Omnibus SB 1421 complaint made in November of 2019. The issues have been narrowed down. We're not going to discuss timeliness or anything like that. The issue basically is that the DPA was not following sunshine rules with regards to SB 1421 records. I even told them about this. They didn't change their tune. And so we have this complaint. So the first issue is 6727. Not until months after I filed the complaint did they start producing any written justifications for withholding. They're doing that for new SB 1421 productions, but they were not willing to agree that they must do so and correct their prior ones, i.e. the ones at issue in this complaint. There's a multiple different 6726 issues. The most obvious one is not until February of this year did they start keying redactions to the above those written justifications. And again, they were not willing to agree in writing that they must correct all prior productions. There are issues like those keys aren't correct, but again, I think I'm not allowed to discuss that here, and I would have to discuss that in compliance if you agree at all that they have to produce keys. We did not know what exactly the records they were withholding. We've found out now that they were withholding an entirety audio records. I am not going to ask you to do anything about that because they have entered into a written agreement that they will go back and produce all the old audio records. Next page. They're also withholding in the entirety video records and index records. And as with the audio issue, their argument was that video records and index records are costly to redact. As you know, in San Francisco, that is not an excuse to not produce records. And as even statewide, as of the National Lawyers Guild versus City of Hayward case, they can't use this, they can't kind of put the cost of redaction on me or any of the other SB 1421 requesters. As far as I know, I don't have a written agreement with them to do video records and index records correctly. And then finally, there's the use of the impermissible balancing test, Penal Code 832.7b6. And this was prior to the mayor's fifth declaration regarding COVID. They told you at the committee that, well, Anonymous can't point out exactly what stuff we withheld under Penal Code 832.7b6, and they're right. I can't because they didn't give those keys, right? But I don't think it's fair to say, well, because they didn't follow the law by telling me, you know, which things are being redacted underneath that, that means that that's not a violation, right? And I think I've already successfully argued that Penal Code 832.7b6 is not a permissible balancing test, as all of you agreed last time with the police commission. So yeah, I would ask that you find these violations. SB 1421 records work just like any other records. SB 1421, all it does, it says that records, police personnel records that used to be exempt under the CPRA are no longer exempt under the CPRA, certain subsets of them, and all the sunshine rules apply. They have slowly come to accept that in most portions, but you know, it's not, some of them apply, all the rules apply, and they should comply with them for all SB 1421 records. I don't think I have anything else. Thank you very much.
Thank you. Are there any persons or witnesses to provide any facts or evidence on behalf of the petitioner? Okay, hearing none. Respondent, Department of Police Accountability, is their representative?
Hello, this is Sarah Monder appearing for DPA. May I proceed?
Wait for Ms. Leger to reset the clock and tell you when to begin.
Thank you.
Are you ready?
Yes.
Go ahead.
Okay, thank you. So this matter is about an immediate disclosure request for all of DPA's qualifying SB 1421 records. The request was made on Thursday, November 28th, 2019, which was Thanksgiving Day. Our office was closed for business that day and the following day for the holiday. The following Monday was December 2nd, 2019, and that's when our staff first received and responded to the request. A DPA staff attorney sent an email denying the demand for immediate disclosure and explaining that the request was not simple, routine, or readily answerable because it was voluminous. The same day, a DPA clerk also responded and explained that we were working to provide all of the previously produced records. The very next day was December 3rd, 2019, and we provided records for 16 cases that had been previously produced to other requesters. So that satisfied the first part of the request. Then on December 9th, 2019, which was 7 days after we initially received the immediate disclosure request, we emailed explaining that we had sent all previously produced files, that we were going through a very large project of reviewing thousands of paper files and offsite storage dating back to the 1980s, and that additional files would be provided on a rolling basis as qualifying cases were identified. After that, we began sending the petitioner case records on a rolling basis as we continued to identify cases for disclosure, redact them, and process them. Then on our office was shut down for business by emergency orders on March 17th, and on March 23rd, the mayor issued the 5th supplement to her emergency proclamation, which suspended many of the provisions of the Sunshine Ordinance. In August 2020, we debuted our new public records portal where we uploaded all of our previously produced files, and that is where we continue to publish newly released files. Then in January 2021, we made cover sheets for all of the files on our portal to explain all of the previous redactions that were made. In February 2021, although the mayoral suspension is still in place, we began keying all redactions with all redaction markings with codes. And to do that, we use overlay text, white overlay text on the black markings. And to make it easier to read, we use shorthand codes like PII for things like personally identifiable information. And now the first page of every case that we produce comes with a cover sheet that explains what each of the codes mean for the redactions. To date, we have released over 27,000 pages of records. They're all publicly available on our portal. And so to summarize and address the issues identified in the initial complaint, I believe that DPA has timely complied with the immediate disclosure request by responding on the same business day that the request was received, and by providing records the very next business day. We also, 7 days later, responded with a statement of the nature and quantity of records that we were remaining to produce to the best of our ability. We provided the cover sheet to justify previous redactions, and we are now adding keyed codes to our redaction markings as we release cases. A few issues have been raised about failing to keep redactions to a minimum. We've done our best to redact a minimal amount of information. I don't believe we have any specific redactions to discuss for this complaint tonight, but I'm happy to answer any questions. The petitioner brought up some issues about the case that we released in February 2021. And although I believe that is a new and separate complaint for this task force to consider, I'm also prepared to answer questions about those redactions if the task force desires. Thank you.
Thank you. Are there any persons or witnesses to provide any facts or evidence on behalf of the respondent? Okay, hearing none, we're now in our question and answer discovery portion. Members, please direct or formulate your questions to gathering more information. After we hear rebuttals, we'll have deliberation on what we found and the merits. Floor is open to you.
Chair Wolf, I have a question.
Member LaHood, go ahead.
Yes, for Ms. Monder, could you speak specifically to, it sounds like you have an agreement with or your department has an agreement with the petitioner regarding audio files. Can you give us your perspective on the status of video files and the requests for video files?
Yes, we do plan to release audio and video files for our SB 1421 cases. Currently, we are only releasing transcripts for audio files because we are waiting for permission to purchase the technology that would allow us to redact the files and we need a technology solution that complies with CGIS information security because we deal with law enforcement files. So we are working on that issue. And because of the purchasing rules for the city, we are waiting for Board of Supervisor approval to purchase a solution that will allow us to redact those files.
Thank you. Do you have is there a projected time? Do you have any idea how long that might take?
I wish I did. We've been trying to purchase this solution for several months. So I apologize. I do not have a projected time for that purchase, but we are anxiously awaiting receiving permission.
Thank you.
Member Schmidt?
Yeah, I have maybe a series of questions for the petitioner. And this is about, it's a legal question. You've got a legal analysis on section B6. And I think we've talked before about this. I'm trying to figure out your analysis here. And this is where I'm going to start. You make a distinction, and I've seen this in your paper several times, where you talk about mandatory exemptions in state law versus permissive or voluntary discretionary. First, do you know what I'm referring to, petitioner?
Yes, I do.
Okay. Now, in terms of, you make a distinction, and first you, I believe, acknowledge this category of mandatory exemptions. And is it true that you're saying to us that in terms of these mandatory exemptions, state law would govern as opposed to a contradictory local law?
I want to be very precise in what I'm saying, so it's not held against me later. I am saying that the 4 subclauses of Penal Code 832.7B5 cannot be overridden by local law because it says, I don't remember the exact words, but the agency shall redact. So I believe that falls under Admin Code 6727B, which is a prohibition on disclosure. And so if the state prohibits you from disclosing it, there's nothing local law can do. That's my view on that specific issue.
Okay, so the word prohibition, is that where you come up with the distinction that you've been making between mandatory and permissive exemptions in the state statutes?
Correct. So what happened, this complaint is the reason why I had to distinguish between these, because if you read the original response from the DPA, they claim that the state is requiring them to do these redactions even in B6. And what I'm pointing out is, no, the wording of B5 and B6 is different. B5 says you shall redact, and B6 says you may redact. And therefore, that B6 is a permissive exemption. That's the word of the Sunshine Ordinance in 67.27A, which is that you're allowed to use any permissive exemption in the CPRA or elsewhere unless it's prohibited by local law. And so my argument is that state law permits local agencies like the DPA to redact based on a balancing test. It doesn't require them to, but it permits them to do so. And our local law says you can't use a balancing test according to 6724I. The same exact argument I made in the police complaint. Yeah.
Okay, so you're saying that B5 is usable in San Francisco, but B6 is not usable, and it actually is the use of B6 is eliminated by the provision in the local ordinance. Is that correct?
Correct. I believe Admin Code 67.24I prohibits San Francisco agencies from using, exactly as it says, Government Code 6255 or other balancing tests, such as in this specific case, Penal Code 832.7B6, and that is reflected in the distinction between Admin Code 6727A and Admin Code 6727B. And I apologize if in the last thing I didn't explain this clearly. I'm not saying permissive exemptions are banned in San Francisco, not at all. Most of the CPRA's exemptions are permissive. What I'm saying is permissive exemptions that are also explicitly prohibited by local law are prohibited. That's what I'm trying to say.
Okay, and this distinction you're making that would permit the respondent to use B5 but not B6. Other than you've said, I believe that. Do you have any other law, any other case law, anything else other than the argument you've given us that supports this argument?
I don't know of any court case that has ever tested Admin Code 6724I to see whether it works or not. So, no, to be very clear, the reason I'm saying B5 is allowed not because it says shall redact. It's the things in B5 are not prohibited anywhere in local law. B5 is not a balancing test at all. It's a specific explicit exemption. So.
Okay. That's all I have for now. Thank you.
Anyone else? Vice Chair Yankee.
Yeah, just a quick question for the respondent. I believe Anonymous discussed that some of the prior records did not have keyed redactions. Were you planning to go back and provide redaction keys for all records that you turned over?
What we did was publish cover sheets for those cases explaining the redactions. We currently don't have any plans to go back and redo those case files.
Maybe you could, can you be a little more specific about what that is? I mean, are they specifically keyed for each of those redactions, or is this just like a general statement you made on the cover page?
Yes, it's a general statement that we made on the cover page explaining that most of the things redacted, well, all the reasons that we could redact, and that the things were redacted to preserve the personally identifiable information, the anonymity of complainants and witnesses, and other all the reasons from SB 1421. So it's a general statement that covers each of the files that we produced. And part of the reason we did that is the constituents that we were talking with when SB 1421 first went into effect, we were prioritizing getting out a volume of cases very quickly, and that was a compromise that we settled on. So those files have already been produced, and currently they just have the cover sheets on our portal so that you can see what types of redactions were made, and a lot of them are very self-explanatory. You'll see a form and it has something that says name, and then you'll see a black box, and a person's name will be redacted.
I guess the part that I'm still unclear about, or is it one reason that you're using for all the redactions, or are there a variety of reasons for a variety of redactions?
There's a variety of reasons.
Someone might need to know that reason 1 applies to the redaction on page 1. Reason 2 applies to a separate redaction, right? They need to be able to match up each redaction with that specific reason. I'm not sure that that's clear based on what you're describing.
Yeah, you're correct. They do not correspond. The redaction markings themselves don't correspond with a redaction reason.
Okay, thank you.
Member Jones Neighbors.
This question's for the respondent. I'm wondering if you could help me understand. This is something I go back and forth with a lot, but I'm thinking in terms of your redactions under PC 832-7B5 for A, personal info of officers. Can you tell me, when you're making those redactions, what are the parameters that you use for personal information of officers? And is that based on a legal definition, an agreed upon definition? Who decides that? Is it, is it concrete? Can you just tell me a bit about that decision-making process?
Sure. So when we are redacting personal information for officers, it's not their name or their STAR number. It is their home address, their date of birth, their personal telephone numbers, that type of information.
So nothing more than that. No any other kinds of identifiers beyond that.
And you referenced a code section. Was that 832.7 B5A?
Yes.
Let's see. There's also B5A also includes identities of family members. So we have personal data or information. It's a such as list. So we start with the idea of home address, telephone number, but there are other ways that the information can present itself that you might not think of. So we might redact a reference to a spouse to protect the identity of a family member.
Okay. And so, one of the things I noticed was that one of the concerns about the redactions also was that there's a requirement that redactions, the name of the redactor is the person who withholds the information is identified. And that was not the case in the records that were released. That person wasn't identified. But were you able to go back then and identify that person or share that information so that we can maybe ensure that that person has the same definitions for the redactions that you're giving us?
So we're all working on the same definition, basically just using the penal code section and also the protocols published by the San Francisco Police Commission. The person who redacted is the attorney who signed for the production letters. So if there's a particular file that you want to know who redacted it, that we can provide that information. But when a case is produced to a specific requester, it's accompanied by a letter signed by an attorney, and that is the person who's responsible for the redaction.
Okay. So if there are cases, so if there were cases where that was missing, that would be something that you would want to correct.
Are you asking about a specific case? Sorry, I'm
Yeah,
not clear.
Well, it seems like there was that there was for at least 4 of the documents, D2, 3, 4, and 5. There were no release letters for those documents provided. So that means that there wasn't an attribution for the responsible party.
Oh, got it. Yes, we could provide that information.
Okay.
Anything else, member neighbors?
No, thank you.
Okay. Any other questions or clarifications, members? I have one question, or I have 2 questions for the respondent. What citation of law are you applying to convert the immediate disclosure request to a standard request?
We did not convert any. I'm not sure. We didn't convert any request to a standard request. We still treated it as an immediate disclosure request. When it came in, we just responded, so an immediate disclosure request requires a response within a business day. We did respond within a business day. We responded on the same day. And then the next day, we provided all of the records that we could provide within that time frame. And then the rest of the request is now going to be complied with on a rolling basis because it was for hundreds of thousands of files and audio and video files. And so those will, the request is kind of bifurcated. The part that we could comply with for immediate disclosure, we did as soon as possible, and the rest of the request, we will respond to on a rolling basis.
Okay, so I'm a little confused because you use some kind of boilerplate language that we constantly hear that sounds like you converted the IDR to a regular request because it's voluminous. Did I hear that incorrectly?
Oh, I did say that, but I don't consider it a conversion. We complied with it as quickly as possible within the spirit of the immediate disclosure request, and then some of it just we could not produce.
Okay, and thus you provided it on a rolling incremental basis.
Correct.
Okay. I just wanted just a bit of a caution because we do hear that from other respondents, and they do intend, their intention is to convert it from an IDR to a regular request under 6721 request, removing the 6725 provision. So I just wanted to get clarification on that. The second question I have is, so I just want to come back to who performed the redactions. It sounds like there were multiple people that did those redactions. Is that correct?
Yes, that's correct.
Okay, and were they done all by attorneys, or were they done by other staff?
It was a group effort. So pages were scanned in by a legal assistant, and some of the redaction markings were done by legal assistants. And then the cases are always reviewed by an attorney who then approves redaction markings and may remove or add additional redaction markings. So the person ultimately responsible for the case is the attorney who signs the production letter.
Okay, great. Thank you. Let's see. I have, let's go to Member Frazier, then Member LaHood, and then Member Neighbors.
Thank you. This is for the respondent, and just briefly, you mentioned that there are time-consuming and expensive burdens to producing video files. I was wondering if you all had an estimate or just a general ballpark of how that was determined and what that kind of threshold and criteria is.
The technology solution that we would like to purchase costs about $100 per hour of media redaction, which is the cheapest that we have been able to find. If we send it off-site to a vendor, it could cost $500 per file. We first transcribe the audio recordings to aid with the redaction of video or audio associated with it. So the whole process of producing media is just very, very expensive. Did that answer your question?
Yes, thank you very much.
Okay, Member LaHood.
Yes, so I guess my first question is to the petitioner. You submitted your request on Thanksgiving Day, is that correct?
I I don't, is that November 28th? I know it's November 28th, so.
Okay, well, but this is relevant to my question because, so for the respondent, is it correct that you believe that the request was initially submitted on Thanksgiving?
Yes, at 1:53 a.m. on Thanksgiving.
So on Thursday at 1:53 a.m. Was your office open on Friday?
It was not.
Okay. So your office was not open on Friday, so the following Monday was the first business day after the receipt of the request.
Correct.
Okay, thank you.
Member Neighbors.
Thank you, Chair. Sorry, I forgot to ask this question earlier. This is for the petitioner. I noticed in one of your emails that you mentioned that the records were only released via Microsoft OneDrive and that you had to authenticate in order to access the records. Has that been rectified, or are you feeling that you are still at risk of needing to identify yourself in order to get the public records?
For the new records, they have placed them on a public portal, but they only started doing this after I filed the complaint some time after that. I want to be clear, I did not ask you for a violation on that because I did not realize that until after I filed the complaint. So.
Okay, thank you.
Okay, last call for any questions or clarifications on discovery. Okay, are we ready for rebuttals? Okay, respondent, you are first. 3 minutes for rebuttals. Ms. Leger will let you know when she's ready.
Respondent, are you ready? Hello? Oh.
Sorry, what was that?
Are you ready to speak?
Oh, I have nothing for the respondent?
Yeah, this is for the respondent for rebuttals, any rebuttals you may have.
Oh, I apologize. I have nothing further to add. Thank you.
Okay, petitioner.
Thank you very much. So I'm just going to clarify what I am and I'm not asking for. But to be clear, I have not complained about the timeliness of their issue. There's no 6725 issue. So Thanksgiving or no Thanksgiving, obviously there's a lot of records here. Obviously they can take rolling responses for however long they need. That's not an issue here. And I believe they did respond in one business day. What matters here is that the same exact issues I brought up with the SFPD and the Police Commission, which is that SB 1421 records fully follow Sunshine. There's no holes in the Sunshine Ordinance with CPRA that this task force, I believe, should kind of create for these extremely important records of police misconduct. And so I would, and while the respondent has told you what they're doing, she has told you what they're doing now, not what they were doing in November or December 2019 when I filed this complaint, which is all the information I had. They did not give cover letters when I filed this complaint. They were just giving out records. So there was no identification of any of the justifications, even if they just want to say, well, it's all under all the justifications. Not even that was given. So even 6727 was being violated at the time. 6726 is still being violated for all the records they gave me originally. There's not an exception that for large records they don't have to key the redactions. You've never held that in any other case, and I don't think you should make an exception now. That's not what the law says. The right answer is to give rolling responses just like you made the SFPD do, and then key the redactions appropriately. And to be clear, a question was asked of them about video records because they'd agreed on audio records. I believe they told you what they were doing, how they're going to do audio records, but there's no progress being made on video records. And SFPD has to give me all the body cam footage. And everyone else, they properly redact it. They use their tools. This is not the kind of information that we can just let go because it's hard to produce. It's not appropriate doing that in any public records request, and I'd say especially in the case of police misconduct records. The records that are being fully withheld due to cost of production need to be produced. I don't think there's any, I don't know why they wouldn't be. The San Francisco law doesn't allow that. And finally, 6724I, for the same exact reasons as you concluded in the case of the police commission, I don't believe they can, thank you, they can use that. So I would ask you to do what's on the bottom of P301, which is page 285 of the PDF, which is to find the respondents violated 6727 for failing to justify withholding of information in writing, 6726 for failing to key redactions, 6726 for withholding the entirety of video and index records, 6724I for the impermissible balancing test, 6253D through 6721K for failing to state the name and title of every person responsible for denying access. And I believe that that would then order the disclosure of the video and index records. Thank you.
Okay, members, time to deliberate and develop a motion for determination. Is there a motion?
Chair Yankee. Oh, I'm sorry, go ahead.
No, you go ahead. It's okay.
Oh, this isn't a motion. I guess it's just a quick question. I don't mean to go back to a question, but it was something that was brought up in the rebuttal that I'm just trying to understand here. And that was regarding the video records. And I believe Anonymous stated that the police department is able to redact these using existing technology that they seem to have. And so maybe the respondent can talk about why their department cannot utilize that same technology to accomplish that.
Hi, yes, I can answer that question.
Are you, hold on, Vice Chair Yankee, are you asking the respondents?
Yes, I'm sorry. Yes. I was asking the respondent why they couldn't utilize that same technology.
Okay, go ahead, respondent.
Thank you. Yes, so we are a separate agency from the police department. We have a extremely modest budget in comparison. We don't have access to the same technology tools. So it's my understanding that the police department is using Axon technology to redact their body-worn camera videos. And Axon is the company that owns and operates the body-worn camera equipment. So we do not have access to that technology, to any sort of account. We don't have direct access to that footage. So when we receive video footage, we receive it like just a file, and it doesn't come with any embedded programming or any way to manipulate the file to, say, do blurring or to distort audio to protect the anonymity of complainants or witnesses. So for a separate agency, we need to purchase our own technology to make those edits to the video, and that is what we are trying to do right now. And the technology that we're trying to purchase would also enable us to redact other types of video besides body-worn camera footage.
Just as a quick follow-up, how long ago did you make the request to purchase that? I guess I'm trying to figure out where the delay is, because it seems like an incredibly important thing to be able to do. And I think it's concerning that it's taken so long. And so where's the holdup taking place?
I can't remember off the top of my head, but I believe it's been about 3 months since we've been trying to purchase. First, we tried other solutions. We tried out some other ways to potentially edit video. We found one solution called Veritone that works for our system and that is CGIS compliant. And we've put in a request to purchase it, I believe 3 months ago, and it was flagged as by the Surveillance Technology Ordinance for additional review by the Department of Technology, and it requires a Board of Supervisors vote for us to make the purchase, and we are waiting for it to be calendared, I suppose. And I'm not quite sure how that process works because the Department of Technology takes over at some point because it's a technology tool that we are trying to purchase.
Okay, so you're basically saying, just to make sure I understand correctly, that everything that your department can do to move this process along has been done, and it's now in the responsibility of another department to continue this process before you can implement the technology. Is that correct in what you're stating?
Yes, that's correct.
Okay, thank you.
Yes, member Neighbors.
I would like to set the video issue aside and make a motion for the remaining violations. And we'll have them on the floor. We can do with them what we will. So I'd like,
Please name them as you make your motion. Thank you.
that we find the Department of Police Accountability in violation of 6727 for failure to justify withholding of information in writing. 6726 for failing to key redactions by footnote or other clear reference to a written justification required by 6727. 6724I for impermissible balancing test. And CPRA Government Code 6253D via 6721K for failing to state the name and title of every person responsible for denying access.
Okay, is there a second?
I was going to ask Lori if she could just, if I could just review that motion with her before.
Sure, absolutely.
Okay. These are remaining
All right,
violations.
can I just interrupt for a second? We're right in the middle of a motion. I would wait until we get a second before we do that. Because if there's no second, then it doesn't matter. Is there a second to the motion?
I'll second it.
Who's speaking?
Stein?
Sorry, Member
Sorry?
Stein.
Member Stein? Okay, great. So moved by Member Neighbors, second by Member Stein. Okay, Mr. Leger, you can go ahead and ask your question.
Motion for finding the Department of Police accountability in violation of 6727 for failing to justify withholding, 6726 for failing to key justifications, 6724I impermissible balancing test, and then you mentioned government codes, and that's where you lost me.
CPRA Government Code 6253D via Sunshine Ordinance 6721K for failure to state the name and title of every person responsible for denying access.
Okay. Discussion on the motion. Okay, let's go to public comment. Public comment is for any members of the public other than the parties. Mr. Leger, when you're ready.
Do we have a speaker, sir?
Any public comment?
Here's one.
Are you ready, speaker?
You tell me when to start, please.
Okay. Go ahead, sir.
Hi, this is Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004.yahoo.com. Beg your pardon?
Continue.
And by mail at P.O. Box 170544, San Francisco, California 94117. The We are not a party to this, and we're not familiar with this, but there was something that was said that I thought was interesting, and certainly would want to draw the attention of the body to, and that is the difficulty that the department, or the time it's taking the department to get approval of technology to redact videos. And I do believe that it was also said that hiring somebody could be a way to do the redaction that is required, or said to be required. And that would cost, I believe, I heard the figures, $100 or possibly $500. So it seems to me that video redaction at present may be more difficult for lack of technology, but apparently could be done by hiring somebody. And therefore, I think it should be taken seriously that the redaction requirement still falls on the department to take care of in whatever way might be necessary. So I hope that you take that into consideration and consider adding that as part of the list of violations, possibly here or possibly in a separate, but I'm not sure there will be another motion, so I would suggest including it or considering it, including the video issue with this motion. Thank you very much.
Next speaker. Any other speakers? Public comment on this motion. Last call for public comment on this motion.
I have a comment.
Go ahead. Mr. Leger, if you're ready with the...
I am ready. Speaker number 2, go ahead.
Hi there. I work at, I've been watching this police reform for a while, and I'm worried that the department re-redacting everything is just going to take a long time. I want these files out now, and I just don't see what we're doing here. That's all.
Okay, thank you. Next speaker. Any other speakers? Okay, public comment is closed. Members, any last words for this motion? Are we ready for a vote? Okay, hearing no objections, please call the roll.
Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein? Member Stein?
Sorry, aye.
Member Stein, aye. Member Frazier?
Nay.
Member Frazier, no. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Forsley?
Aye.
Member Forsley, aye. Member Schmidt? Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion for remaining Department of Police accountability violations are 6727, failing to justify withholding, 6726 for failing to key justifications, 6724I, impermissible balancing test, Government Code 6253B, Sunshine Ordinance 6721K for failing to state the name and title of every person denying access. Is that
Okay,
correct?
just wanted to make sure on that last one, it's 6253D is in David.
Okay, thank you. Thank you. Didn't hear that.
Okay, great. Are there any other motions for this item? Okay, seeing none, let's go directly to our next item.
Item number 5, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction, but not on today's agenda.
Okay, I just want to preface this by saying, members, if you, and members of the public, anybody who's speaking, please self-moderate. And if there's any offensive language that is deemed to be under our decorum provision, please interrupt and call it out, and I will take it from there. Thank you. Let's have the first speaker.
Hello, first speaker.
Well, maybe it is. It's me.
Hello, speaker number 1. Go ahead, sir.
This is Peter Warfield, Executive Director of Library Users Association, and I would ask the chair to ask whoever is making outbursts to not interrupt my public comment. There should be opportunity if there is objection from somebody to hear it. Anyway, this is Peter.
Mr. Warfield? Mr. Warfield, I think you muted yourself. Mr. Warfield? Excuse me, Chair, I'm not hearing from
Yeah,
the.
Can you hear me?
Yes, we can hear you.
Can hear you.
I don't know what happened. I didn't touch anything, and then I heard a bunch of you're in, you're out, you're in, you're out. Did you hear that?
No, but please restart his time.
Yeah.
Okay, tell me please when to start, and do I have 3 minutes?
Yes, sir, you have 3 minutes. You may begin.
Thank you. This is Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com and by mail at P.O. Box 170544, San Francisco, California 94117-0544. And again, if anybody has objection to identifying who we are and how to reach us, I would certainly be glad to hear about it, but I think this is not the time for interruptions. I have 3 points to make. The first one is that I hope that the task force has already or will, members will attend remote meetings as members of the public. I have to say that remote meetings have many, many differences from the actual real meeting, and in fact are different one from the other. For example, your practice of not muting anybody automatically or during the meeting, I think is excellent. But other places you have to be muted and unmuted and so on to even get a chance to speak. And there's a whole range of things that people hear in the public when you're participating in public as a member of the public that not everybody is hearing or aware of or present with. So there's a whole range of differences, and I think also being in charge of the meeting is different from being an attendant, attending as a member of the public. And also I would urge you to try it by telephone, which is how some people, including myself, either have to attend or choose to attend. Second, I heard Supervisor Aaron Peskin at the Rules Committee January 25th, and he talked about some of the problems of the task force. He talked about a backlog as well as what he called a lack of staffing. I've talked about some of these things certainly, and it's a hell of a tough job to work on the task force and to administrate the task force. It's certainly not a job that I think many people could handle. But he immediately mentioned with lack of staffing, which we are hard pressed to afford. That was a little discouraging. And then he talked about having spoken with the chair, who was one of the people being reappointed, and they had talked about some of the problems and some of the solutions, consolidating complaints, resolving at subcommittees or with facilitated and so on. And none of it included maybe looking into the tremendous number of complaints that are received and what the supervisors might do. Finally, I received a phone call from the chair who said there had been complaints about my public comments at a previous meeting, and I'd appreciate hearing directly from anybody who has an issue. Thanks very much.
Next speaker.
May I comment? Is it not?
Speaker, are you ready?
Yes, I am.
Go ahead, sir.
Thank you very much. So as I believe the Department of Technology informed one or two of you on the task force, and I believe it might have been the chair and the vice chair, the tool for metadata has been released. Agencies appear to actually be complying with your orders. They are releasing the information. The Office of the Mayor has actually offered a consent agreement that they will produce without fighting this anymore. The things that you have ruled now, I think 7 times on regarding exact copies, full email production. You get the email addresses, get all the attachments, you get everything that the government communicates. Oh yeah, and including the email headers and metadata. And I know that some of you who have been on task force much longer have said, you guys have been saying this for at least 14 years now. It's not something new, and it's really I think it's a really positive step that the government is actually complying with what you're saying, and I hope they do so more often than not. I know I hear other people's complaints. The government doesn't always do what you say, and they'll just sometimes say nothing and do nothing. They have no argument why. That's not appropriate, and the whole point of the Sunshine Ordinance, at least one of the most important points, is that 11 volunteer members of the public with a wide diversity of experiences and backgrounds are the ones who get to decide what is public in San Francisco, what the rules the government has to follow, instead of the government deciding on its own what it can give the public. And I hope that the government does this in more cases, that they realize, okay, yeah, we're wrong, and they start complying with the law. Thank you very much.
Thank you. Next speaker. Any other public comment? Any other public comment? Last call for public comment. Okay, public comment is closed. Let's call our next item.
Item number 7, file number 20079, complaint filed by Shane Anderes against the District Attorney's Office and Chesapeake for allegedly violating Administrative Code Section 6721.
No, Mr. J, let me interrupt you. It's item number 6.
I thought we discussed that was one of the cases that was pulled.
Oh, was it?
Yeah.
It was the last one. It was number 8 that you told us that was pulled.
Number 6 too. 20077.
Okay.
All right. I'll repeat it, and then we can make a notation in the minutes that it was closed. I mean, it wasn't closed, it was withdrawn.
Okay.
Do you want me to do that?
Yes, please.
Yeah. Item number 6, file number 20077, complaint filed by Tom Borden against Recreation and Parks Department. Oh, no, you're right. This was not pulled. This was another one. I apologize. Recreation and Parks Department for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and/or complete manner. I apologize. That was a different case that was pulled.
And the byline underneath it, please. Can you
March
read that?
16, 2021, the complaint committee found that the task force has jurisdiction to record the public and referred to the task force for hearing.
Okay. Complaint committee chair Schmidt, do you have anything you want to add?
Just that we forwarded it. It's pretty straightforward. I would defer to members of the committee. Do you have anything you think should be noted on this?
Where's my? If I recall correctly, I think there was some expression on the part of the respondent that they were going to get the additional materials to the petitioner, and I just would want an update kind of upfront from the petitioner about whether that happened.
Okay, well, we'll hear it when the testimony comes for sure.
Yeah.
Thank you, Member Stein. Any other complaint committee members have anything they want to add?
I do know there was some controversy about drafts that had not been produced, and I want to make sure that they have now been produced, because I guess there was a misunderstanding about the scope of the law.
Okay.
But that's all I have.
Okay, great. Well, let's get to it. Let's see if we can wrap this up by 6 and stay on time. Okay, Ms. Leger, if you're ready, we'll hear from the petitioner first. Mr. Borden, are you present? And let's ask if the respondent is also present. Is there
This is Tom Borden, I'm present.
Okay, is there a representative from Rec and Park? Is there a representative from the Rec and Park Department? Okay, members, it doesn't seem like the respondent is present. If there are no objections, then I'll assume that we'll continue. Okay, hearing no objections, let's continue. Mr. Leger, if you're ready with the clock. Mr. Borden, you have 5 minutes.
You ready, sir?
Yes, I am.
Go ahead, sir.
Okay, so I requested information. Rec Park provided incomplete information, and I made a second information request, and they didn't provide any additional information. And there clearly were things missing, a large project area that involved quite a bit of the funding for the project. No map was provided, even though there were trail lengths and things that were part of their calculations. A second area on visitation was another project area where no map was provided. And the biggest thing was 1.5 million of spending from their stated budget was unaccounted for. And in my second request, I asked specifically for what that was, to account for the other 1.5 million, and they said they had no additional information. And then at the hearing that was just referred to, they said, "Oh, we didn't know he was asking for information about that 1.5 million." And they said they had it and that they would provide it, and they haven't provided anything since then. So, I mean, it's pretty, I don't know, if you have questions, I'll answer them, but it's pretty straightforward to me. They just don't want to provide the information.
Is that the end of your testimony, sir?
Sure.
Okay, thank you. Are there any persons or witnesses to provide any facts or evidence on behalf of the petitioner? Okay, hearing none. Is there a representative from the Recreation and Parks Department? Calling out for a representative from the Recreation and Parks Department. Respondent. Okay, let the record show that there was no response. Are there any persons or witnesses to provide any facts or evidence on behalf of the respondent? Okay, hearing none, members, the item is with you for questions and clarifications.
If I could, I'm sorry, go ahead.
Go ahead, Member Wong.
This is Member Wong. I was just going to ask for Member Stein to clarify on the documents that were being awaited that were mentioned in the complaint committee.
Can you hear me? Yeah. Yeah, well, I would say that the petitioner gave a pretty accurate summary of what happened, which was that, you know, there was a meeting where they said that there was like a $4 million budget for something. And then when they gave documents, it only showed about $2.5 million worth of expenses. And then they did say in the meeting, the respondent did say in the meeting that, oh, they didn't realize that, you know, there were other documents that would help explain that figure and that they would give them. So, you know, we didn't know exactly what documents those were, but presumably something that helped them create the budget for that particular project. So I was under the impression after that meeting that this case would probably be withdrawn if they came up with that documentation, but it hasn't been provided.
Okay, thank you, Member Stein. Member Schmidt.
Yeah, my take on this is I initially wondered if he simply was asking for documents that you would think would exist, but that they had not created those kind of documents. And so they had been responsive in that the documents didn't exist. At the hearing, I know there were at least some documents that were acknowledged, that were responsive, that had not been produced. And I thought, I'm in accord with Petitioner that it seems like there are some unproduced documents that were requested. And I think that's pretty much what the case is.
Okay, Member LaHood.
Yes, I have a question for Ms. Leger. Did we hear anything from the respondent, any acknowledgement of this meeting or response that they might have difficulty attending?
No, she didn't say she would have difficulty attending. When we talked about the item, the Brecken Park item that is the last case to be heard, I told her that this case had been withdrawn, and I expected her to appear for the other case, for this case.
I'm a little surprised based on what the committee members said, because usually when respondents show up for a committee meeting and indicate that they're going to provide additional records, for them not to show up is a bit surprising, but that's a clear violation not to have sent a knowledgeable representative to this meeting.
Okay, any other questions or clarifications needed? All right, shall we move to rebuttals? Okay, let's do so. Again, I'll call out for a representative from the Recreation and Park Department. Member Stein, can you mute, please? And Member Schmidt, can you mute, please? Thank you. Okay, Petitioner, Mr. Borden, you have 3 minutes.
I would just like to say that this has been an ongoing pattern from Rec and Park, particularly their group that manages the undeveloped parkland in all of our city parks. And they've stonewalled many of my requests over the years, and that's why I'm sort of doggedly pursuing this to the end, because it's just there's public information. People want to know what they're planning to do and what their justifications are, and this isn't the first time I've had a complaint with you folks and over Rec and Park, and there's another one brewing right now. So I don't think my request was unreasonable. I think it's when I asked in my second sunshine request, this leaves 1.5 million unaccounted for. Please provide the rest of the budget that shows the missing cost elements. And then at the meeting, the Sunshine Task Force meeting, we had, for them to say, oh, we didn't know he was asking for the other elements that account for the other 1.5 million. We have that. We'll get it for them. And then, of course, then they did nothing. So it's an ongoing pattern, and that's all. Thank you.
Okay, thank you. Okay, members, time to deliberate and a motion.
Can I make a motion, or is it too early to do that? This is member
No,
stuff.
no, this is the exact time
Okay.
to do that. If
I
there's
didn't know if you went- okay.
no other deliberation, to come up with a motion.
Yeah,
then
so I
go
would
ahead.
just make a motion to find a violation of section 67.21 of the Sunshine Ordinance, failing to respond in a timely and complete manner to this request.
This is member Frazier, and I second.
Okay, moved by member Stein, second by member Frazier. Any comment on the motion? Any debate on the motion?
Do we want to add a violation for not sending a qualified representative to this task force hearing?
That was member LaHood.
I can add that.
Please cite the,
Oh, I don't have it in front of me. Does someone have this section in front of them?
I think it's 6721E. This is Vice Chair Yankee.
Maybe you want to add the amendment. But okay, I'll just say to add a violation of 67.21E for failure to send a representative to the hearing.
Member Frazier still would second that.
okay, great. So you'll accept that amendment. Okay, just so for everyone's edification, it's the last sentence of the paragraph. An authorized representative of the custodian of the public records requested shall attend any hearing and explain the basis for its decision to withhold the records requested. Just so you feel comfortable about what amendment you're making.
Yeah, I know what it is.
Okay. All right. Let's open up for public comment. Mr. Leger, I hand it to you.
Do we have a speaker?
Yes.
Are you ready, sir?
Yeah, can you hear me? And let me know when I can start, please.
You may begin.
Thank you. This is Peter Warfield, Executive Director of Library Users Association. We can be reached at libraryusers2004@yahoo.com. Also by mail, P.O. Box 170544, San Francisco, California, 94117-0544. Thank you very much for the process you've just gone through and the motion that you've made. We certainly support that. Library Users Association, like many other folks, is very concerned that the whole city should be providing the information that people are legally requesting and entitled to. We're not a party to this, and we are not familiar with the case, but I'm glad you're insisting on attendance. And I do have a question for the consideration of the group, and that is whether this might be a willful violation. The complainant has said that there is a pattern and not only apparently of violations, but I'm not clear entirely whether the pattern also includes making promises, such as was reported having happened at the committee level, where they said they would get information and then did not follow through as promised, produced nothing as was reported, and then didn't even show up here. I think that that's a situation that the task force can, can make a determination on. I'm right now not entirely clear when or how or under what circumstances, but this certainly sounds like it might be an instance where the task force might want to consider violation finding and including it in the motion. Thank you very much.
Any other public comment on this motion? Last call for public comment on the motion. Okay, any other discussion, members? Public comments closed. Any last discussion, members, on the motion? Are we ready for a vote? Hearing no objection, Mr. Leger, please call the roll.
Member Stein?
Aye.
Member Stein, aye. Member Frazier?
Aye.
Member Frazier, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Forsley?
Aye.
Member Forsley, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Wong?
Aye.
Member Wong, aye. Member Yankee?
Aye.
Member Yankee, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion to find a violation of 6721 for failing to respond in a timely and complete manner to the request, and 6721E for failure to send a representative to the hearing.
Okay, great. I will call for a recess until 6:02. If there are no objections, we are in recess. Please mute your microphones and telephones, please, and turn off your video. Thank you.
How you doing, bud?
Sorry about that. I logged myself out by accident. Okay, we all back? Looks that way. Okay, let's call the next item. We're back in session.
Yes. Item number 7, file number 20079, complaint filed by Shane Anderes against the District Attorney's Office and Chester Boudin for allegedly violating Administrative Code Section 6721E by failing to respond to a records request in a timely manner, 6725, by failing to respond to an immediate disclosure request in a timely and or complete manner, 6726, for withholding kept to a minimum, and 6727 failing to provide justification for withholding of responsive records. I will read the conclusion, the italicized. March 16, 2021, the complaint committee found that the task force's jurisdiction, the records are public, and referred the matter to the task force for hearing. In addition, the committee requested that the respondent provide information regarding how their search was conducted and what search terms were used. The committee also requested that the complainant provide information regarding the rationale in this specific case about attorney-client privilege and subsequent response from the respondent.
Okay. Complaint Committee Chair Schmidt, do you have anything to add?
Nothing from me. I think that sums it up for me, but I also, again, defer to members of my committee.
Okay, hearing none, let's begin. Are both parties here? Mr. Andrews?
Yes, I'm here.
Is there a representative from the DA's office?
Yes, Robin Burke from the DA's office.
Very good, thank you. Ms. Leger, when you're ready. Petitioner, Mr. Andrews, you have 5 minutes.
Mr. Andrews, are you ready?
Yes, I am.
Go ahead, sir.
So I had received a letter from Ms. Burke yesterday detailing, again, what they had done to search for responsive documents, primarily any emails to or from Mr. Boudin regarding Mr. Osley. The letter confirmed that she had personally conducted an email search, that there was nothing responsive, that there were, did not produce anything, but indicated there were 5 responsive documents that were being withheld under claim of attorney-client privilege. I had emailed her before today's hearing late in the afternoon, so on somewhat short notice, but I said that I was inclined to go ahead and take this matter off calendar if she could go ahead and confirm that her search included some messaging software that I'm aware DA employees used, and also to confirm whether the search went back to January 19 of 2020 when I sent an evidence preservation letter to the DA's office to make sure that information had in fact been retained. While waiting for our matter to be called, I was flipping through the file and have come to realize that there were several documents that were responsive to this initial request that were not produced, that are in fact emails to or from Mr. Boudin referring to Mr. Osley that were not produced, that are not attorney-client privileged. And so I guess, you know, in the interim, I'm happy I didn't withdraw the matter from hearing, because at this point, I'm just questioning the accuracy or the thoroughness of the search for records. Sounds like I'm almost out of time, but I'll just reiterate something I heard Anonymous and other people saying, is that the ability to search emails, including attachments and embedded documents, is there now, so there shouldn't be a reason that information was not produced. And so I guess, you know, I guess I would want the committee to reaffirm the violation of the ordinance insofar as it failed to produce responsive documents, and I'd like it to go back and try again and confirm more precisely what it had done, since at least I think there are responsive documents that were not produced. I did email those to Ms. Burke and copied your committee, in fact, while I was waiting, just in the event anybody wanted to see what I was referring to so it could be easily circulated. Other than that, I have nothing else. Thank you.
Thank you very much. Are there any persons or witnesses to provide any facts or evidence on behalf of the petitioner? Hearing none, respondent, you have 5 minutes.
Thank you so much. I am just getting a chance to review the documents that Mr. Andrews sent over, and I wanted to make sure that it's on the record that the request was received on February 4th, 2020, and it asked specifically for all records between January 1st, 2019 and present. So that would have been February 4th, 2020, specifically communication to or from Chesa Boudin regarding Thomas Osley. The email that Mr. Andrews sent over that he is calling into question is an email from Kelsey Russum to Chesa Boudin that was sent on January 22nd, 2020, and it has in it the results of a survey. And so when it was pulled, when we did the search, it wasn't initially pulled out as having any mention of Mr. Osley, because it was an attachment, and I recognize that should have been disclosed. And then the second email that he's referring to is a letter that was sent on October 30th of 2020. So it was after the initial request. So we would not have had this to disclose at the time of the response, since it was months after the initial request.
Does that conclude your testimony?
Yes, it does.
Okay, thank you. Are there any persons or witnesses to provide any facts or evidence on behalf of the respondent? Okay, hearing none. Members, questions, clarifications for discovery? Matters with you. Member Padmanabhan?
Yeah, this question is for the respondent. I just heard you say that there were some documents. There was one document that was an attachment. So does that mean that your search term, that the search terms that you, the department or you used to search for these documents did not include attachments?
It did include attachments, and so I'm concerned as to why this one wasn't pulled during this search, but was pulled during a secondary search. And so I need to get with my IT department to understand why it would have missed this one this time, and it could be the way that I searched versus the way that they searched.
Anybody else? Member Schmidt?
Yeah, for respondents, what's the number of documents that would be responsive that your department has withheld under privilege?
There were 5 documents withheld under attorney-client privilege.
Okay, and so that hasn't changed at any time since you first determined the 5?
No, it has not.
Okay, and that and you've identified that it's in this case it's the client being the district attorney or the district attorney's office, and the attorney involved being the city attorney's office, correct?
Yes.
Okay, thank you. Nothing further.
Okay. Any other questions, members?
I would just like, yeah, I don't know if this is the time for it, but I wouldn't mind hearing from the petitioner about whether the respondent's statement satisfied their concerns about what they might or might not have received.
Sure. Petitioner, you may respond.
Sure, this is Shane Andrews. Yes, I'm satisfied, and I certainly understand the difficulties of e-discovery and trying to locate things to produce. So I'm satisfied to the extent it sounds like Ms. Burke would be willing to go back and communicate with her IT person and to sort of confirm once more, perhaps with a little bit more detail, what specifically was done, just so I can be sure that in fact there isn't any other documents that have not been, excuse me, produced. There's only one concern I do have, and that's if I understood Ms. Burke correctly, she was indicating that, at least I think it sounds like she was under the belief there was no obligation to produce any documents past the date of the letter based on the request that the DA's office produce everything from a certain date in 2019 to present. My, common understanding is to present means on a rolling basis. So if my letter was sent yesterday, it would also include any documents responsive as of today, that it doesn't somehow cut itself off. And so I'm a little bit concerned, if I am understanding her statement correctly, that is what happened, that information beyond the date of the letter request was not even considered or reviewed for production. That would certainly be a much bigger problem in my mind, and I would want confirmation that in fact, when the DA goes back and reviews the information again, that it's from the date of my request all the way through present day. In other words, the date of production.
So I have a question, this is Chair Wolf, for Mr. Andrews. At the time that you filed the request, it was for what period of time?
I'm pulling up the request again. From January 1, 2019 and present.
To present, okay. Okay, thank you.
Okay.
Anything else, members? You ready for rebuttals? Okay, let's move to rebuttals. Respondent, DA's office, you have 3 minutes.
I have nothing to add.
Okay, thank you. Petitioner, you have 3 minutes.
Nothing to add other than identifying for the record that software app I was referring to is called Signal. There's a number of apps out there where you can communicate where the message, I think, automatically erases after a certain period of time, which can be set by the sender. But I still would like to know whether the Signal app was searched, given my understanding that employees use it, and because I had sent an evidence preservation notice that would have encompassed those communications. And so for me, I would want to know if that evidence preservation notice was communicated to the relevant or necessary parties. Otherwise, I'm concerned that there's more than a year's worth of potential responsive information that was simply allowed to erase over time, despite my notice.
Okay, thank you.
That's it. I'm done.
Okay, thank you. Okay, members, the matter is with you for deliberation and motion. I'm sorry, Member LaHood, go ahead. You have your hand up.
Yeah, I have a question about Signal and automatically disappearing messages. This is actually to the task force. Have we decided? Has that come up before? Have we had any previous, discussions where there was an automatic setting rather than somebody willfully going through and deleting old messages?
Not to my knowledge has it come up. I know that there has been some, I think there's been some news articles about the use of such, not just Signal, but even before Signal came out, like what I think it was WhatsApp or something like that. There were a couple other similar type of apps out there that would do that. When the Smith versus San Jose ruling came out. But I don't think that there is, there's been any official policy for the city and county government. That meaning I'm not sure at all. Yes, Vice Chair Yankee, go ahead.
I guess just a question based on that. Maybe the respondent could clarify whether or not they did search any Signal app, I think it was called, messages that still remain. Was a search done on those for the respondent?
I did the search in January of 2020. And to be honest, I searched his phones, but I cannot recall all of the apps that I searched. I apologize. I've had a baby and been in pandemic childcare since then, so my brain is not as sharp as it once was. But I can double check with him.
Thank you.
Okay, members, is there a motion or any further deliberation or debate on the matter? Is there a motion?
I can make a motion.
Okay, member
Motion
Manava?
to find a violation of 67.21, failing to respond in a timely or complete manner. 67.26, withholding kept to a minimum, and 67.27, justification of withholding.
Okay, I think you meant 6721E.
6721E, that's right.
Great. Is there a second?
I'll second it.
Please state your name. Who is the seconder? Is there a second? Members, is there a second?
This is Member Frazier. I'll second.
Okay, thank you. Member Frazier seconds it. Is there any deliberation or debate on the motion to find a violation of 6721E for failing to respond to a records request in a timely or complete manner, 6726 withholding kept to a minimum, and 6727 for failing to provide justification or withholding responsive documents? Vice Chair Yankee.
Yeah, I guess that should just be for the task force, or maybe for the maker of the motion. What records in particular would you be referring to in that motion? Would this be the one that was the attachment that was dropped, or were there other ones that you're including within that motion?
I'm referring to the 5 documents that were withheld.
The 5, or those the ones under attorney-client privilege?
Attorney-client privilege.
So, or are we making an assertion then that they should not have been withheld under attorney-client privilege?
I'm making that assertion. Yes.
Okay.
Vice Chair Wolf, I would just state also that I'm more interested about the justification for the attorney-client privilege for withholding those documents. And the question then becomes who's that? I guess I think, as you mentioned, Vice Chair Yankee, that the DA's office is the client and the city attorney is the attorney of record. Is that correct?
That's correct. Yes, that was my questions to the respondent.
Okay, thank you. Okay, any other comment, any other discussion around the motion before I open a public comment? Go ahead, Member Schmidt.
Yeah, I mean, I would just say that I'll vote no when this comes on, because I don't understand trying to say there's a violation with regards to something that's clearly privileged. But that's just wanted to tell you that's my position on this.
Okay, Member LaHood and Vice Chair Yankee.
Yeah, in the event that this passes, I would like some clarification from the task force about the topic that came up with such and such date to the present. My interpretation of that would be the date that the request is made, because the present is forever moving forward, and we would not be able to set a boundary on what information we're talking about. I think if the request also said to date, and I would like updates anytime this comes up in the future, I feel like that is a different kind of request. But as saying such and such date to the present, to me sets bookends on it, and I'd just like to know that that fellow task force members would agree with that should this go to compliance.
Well, let me just jump in for a second on that, says Chair Wolf. I would say that if there was a if there was a call for a rolling incremental rolling basis for providing documents, the question would then become, what is a reasonable period of time for it to come to the present? I don't necessarily think. I think at some point, when you take it to the point of filing the complaint, that at the time of the complaint, enough time has passed that the word present is somewhat meaningless, because it's obviously there hasn't been a response, for a fairly long time, as to what the status is. So I would think about it from that perspective. Vice Chair Yankee.
Yeah, I was just going to essentially kind of make the similar comment as Member LaHood did, that I'm not sure in this particular instance it was clear that present meant on a forward-looking basis. I probably would have, taken that to mean present as of the date that the request was made. So from my perspective, the only potential issue I'm seeing is the one attachment that was not included in the initial batch of documents released, but it sounds like it may have been released in a subsequent batch. But I'm in the same position as Member Schmidt regarding the attorney-client privilege documents. I've not heard any compelling testimony up to date showing that those should have been, or for some reason that privilege is being improperly used in this instance. So I'm a little uncomfortable with the broadness of the motion as it is.
Okay, so I'm hearing some dissension through through discussion, that there may be some concerns with the motion. Is there any amendments to the motion? Because if, as Member LaHood was pointing out, as this goes to be monitored by compliance amendments, they need a clear idea of what exactly the order of determination is. So we've heard from Member Padmanabhan that she's referring to the 5 documents that were held under attorney-client privilege, and we've heard from Member Schmidt and from Vice Chair Yankee that the concern is really around a matter of maybe 1. Is there any meeting of the minds here for that? If not, we'll put it to a vote, and we'll.
I will also throw in there, since we didn't get clear. It sounds like the respondent, who was the representative here today, did not have a clear answer on whether the signal messages were also kept, or whether, searched, and whether there was. Whether, if there was any automatic deletion happening, if that was stopped when the request was made to preserve records. I don't know. I would present that as a possible area to explore.
Right. I just want to express to everyone that if you have concerns about something, and you think that it's not correct, or you think that it should go in a different direction, I would attempt to put that out as a motion to make adjustments, and not see if somebody else picks up on it to make a motion, just so we're not spinning our wheels here.
I'm sorry, I was doing that to let the original makers of the motion modify, but I can come back with something if needed.
Okay. It's up to you. I'm just opening. I'm not making a request. I'm just stating that's your option and your prerogative under our parliamentary procedure. Vice Chair Yankee.
I'm not sure that now is the appropriate time for a second motion since we already have one on the floor, but along the lines of Member LaHood, I think it might be worth, regardless of how this goes, exploring that and perhaps continuing this and giving a time frame wherein the DA's office can perform that search that Member LaHood spoke about and report back to the committee and to the petitioner if that search found any additional documents or not. Just confirm if that had been done or not.
Are you suggesting that we postpone this motion and move to a continuance?
That would be what I would propose, but I don't know if we need to vote on the motion that's already on the floor first.
You can make a replacement. Well, if we make the motion that's on the floor first, then having a continuance is somewhat moot, because an order of determination would be somewhat final. So I would suggest if you want to make a replacement motion for the one that's on the floor, that you do that as an amendment.
Okay, I would move to amend the motion for continuance to allow the respondent to search the Signal app messages and report back to the task force and the petitioner with those findings within, let's say, 30 days. That would be, by the next meeting.
And for it to be monitored by the Compliance and Amendments Committee?
Sure, the compliance with that, yeah.
Okay, great. Is there a second?
Actually, can I make a comment on that regarding that motion, or do we need a second first? I could second it.
We need a second first, unless you want. I would say get a second first, and then we can work on any clarifications.
I'm going to hold.
Okay, is there a second on Vice Chair Yankee's motion to replace the original motion to continue this file?
This is Member Wong. I'll second that.
Okay, moved by Vice Chair Yankee, second by Member Wong. Member LaHood, go ahead.
So my concern is that when we say 30 days out, but we think about setting what's on the agenda for the next Compliance and Amendments Committee meeting, I think we're actually going to end up more than a month out, because that is my you know what though, I guess that's how we do things. I mean, I can
we could do 15 days if you think that might be more time efficient to get it on your next agenda. I'm open to amending what I had stated day wise. For LaHood.
I'm looking at the you know what, I don't want to hold people up while I'm searching the calendar, because our next Compliance and Amendments Committee meeting is the 25th.
This is Member Stein. Can we ask for this to be searched for or resolved within 1 week from the respondent? Do you think that we could ask the respondent if that's a reasonable timeline to do this small search?
I think that's a great question.
Ms. Burke, you're free to respond.
Yes, I think that would be okay.
Okay, so I'll change my motion to continue to have that done in 7 days instead of the 30 days.
Okay, and that some form of communication.
Yes, to be sent to the petitioner and to the task force that the Compliance and Amendments Committee can review it at their next meeting.
Okay, Member Wong, do you accept that?
I do.
Okay, great. Okay, so this is a motion to amend the original motion. We will vote on whether to accept the amendment. If the amendment is approved, then we will go back and vote on the new motion that has been replaced. Everybody understand?
Oh, what are you trying to do, Bruce?
Okay, so we have a motion on the floor that was made by Member Padmanabhan and seconded by
Member Frazier.
Member Frazier. And then we now have an amendment to replace that motion by Vice Chair Yankee and seconded by Member Wong to continue the file, and that the respondent will perform the functions, and I don't recall exactly what there was to do the search for in the Signal app. Was there something else besides that, Vice Chair Yankee?
No, that was it, the Signal app.
Okay, right. Within 7 days, and provide confirmation of the results of that to the petitioner, to the requester, complainant, and to the task force. And so when we vote on this amendment, if it is approved, then that will replace, that means we're approving or we're agreeing to replace the original motion, and then we'll call for the original motion because it'll be now a brand new motion. So this part is just purely operational, and the second one will be the actual approval of the motion. This is just an approval of the amendment. Okay. Any other discussion on the amendment? Okay, seeing none, let's open it for public comment only on the amendment. Any public comment on the amendment? Okay, hearing none, are we ready for a vote?
Chair Wolf,
yes.
Can we also verify that with Signal, we're also seeking information as to whether messages were being deleted automatically, and if so, if that was stopped when the request for those messages to be searched was initiated?
I would only suggest that there be an attempt made, because
yes,
apps like that do not have logs, I don't believe.
Right.
And if they don't have a log, there'd be no way to know. So
thank you.
But I mean, if you want to add that, I would, again, I mean, I want to extend this.
I'd like to make an amendment to the amendment that to the degree that it is possible, given the limitations of the app, that the respondent inquire as to whether the search was done at the time it was initially requested, and that we get a yes/no response to that, and if not, that the search be done now.
Okay, let's do this. We're just doing an operational thing to replace the original motion. Once we see if that's been approved, then your amendment would be appropriate. If this part doesn't make it, then your motion becomes moot. So just for the sake of a procedure here, generally you don't do amendments on top of amendments. So the amendment is purely operational, first to either make a correction or to make an adjustment. Once we get through that, then the original motion will be on the floor. You're free to make any other amendments you want on top of that. Okay. Her signal is frozen, so I don't have an acknowledgement. Okay, there we go. Got an acknowledgement. Okay, let's please call the roll, Mr. Leger.
Member Yankee?
Aye.
Member Yankee, aye. Member Wong?
Aye.
Member Wong, aye. Excuse me. Member Frazier?
Aye.
Member Frazier, aye. Member Padmanabhan?
Aye.
Member Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein?
Aye.
Member Stein, aye. Member Forsley?
Aye.
Member Forsley, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. Okay, I will read the motion as it has been amended. Member Yankee moved to amend the original motion to continue to allow the respondent to provide a signal search be performed within the next 7 days to confirm the results of that search at the next task force meeting. Now, are we going to include a review by CAC or not?
Yes.
Okay. Confirmation of the results of the next task force meeting and that the issue continued to be monitored by the Compliance and Amendments Committee meeting. Next Compliance and Amendments Committee meeting. Does that make
Correct.
sense?
Yes.
Okay.
Okay, so that's our new motion on the floor. Now, Member LaHood, do you have?
Yeah. So based on the text of that motion, we know that a search is going to be conducted now. I would also like an answer to the question whether a search of the signal messages was done when the request was first made.
I'll second that.
Okay, I was going to ask, or is that a motion?
That was, yes, that was an amendment to, or do we need a new motion?
No, well, if you're going to make an amendment, that is a motion.
Okay, that's my motion, yes.
You move to amend.
I move to amend that in addition to requesting a response on the signal search, that we get an answer as to whether a signal search was performed when the sunshine request was initially made.
Okay, is there a second?
Vice Chair Yankee will second.
Vice Chair Yankee seconds it. Okay. Discussion. Okay, hearing no discussion, so for public comment. Any public comment on the motion?
Yeah, I have public comment.
Okay, Ms. Leger, when you're ready. And this is a public comment on the motion to amend.
May I start?
Hang on. You may begin.
Okay. Yeah, I have two concerns. One is, even 7 days, it just seems like a very exorbitant amount of time for something as simple as searching through an app. I understand that, there are holidays and weekends, and I suppose some staff member would need to do this, but it's Wednesday, right? So I guess Mr. Boudin would need to get his, I suppose, I don't know where the phone is. I don't know if Mr. Boudin has like some sort of secretary or something that he interacts with in person now, but presumably he could get the phone to this person by tomorrow or by Friday at the latest. And then this person, it shouldn't take them more than a day. It should probably only take them, half an hour to do this, right? Maybe an hour. And so like a week seems like a lot of time. And then my second concern is if presumably all these records and stuff are supposed to be accessible. So why are public officials even using Signal in the first place? Like, why is this permitted? I don't know if this phone was a personal phone. Well, I presume it was probably a personal phone. But why does he have Signal on his phone, and why is this allowed if all of his communications are supposed to be accessible by public records request? So yeah, that's everything I had to comment on. Thank you.
Thank you. Any other public comment? Last call for public comment. Okay, public comment is closed. Are we ready for a vote? Hearing no objections, please call the roll. This is on the amendment.
Okay, who seconded the amendment?
It was moved by Member LaHood, second by Vice Chair Yankee. And could everybody please mute their microphones? Thank you.
Okay, Member LaHood.
Aye.
Member LaHood, aye. Member Yankee.
Aye.
Member Yankee, aye. Member Frazier.
Aye.
Member Frazier, aye. Member Padmanabhan.
Aye.
Member Padmanabhan, aye. Member Neighbors.
Aye.
Member Neighbors, aye. Member Stein.
Aye.
Member Stein, aye. Member Forsley.
Aye.
Forsley, aye. Member Schmidt.
Aye.
Member Schmidt, aye. Member Wong.
Aye.
Member Wong, aye. Member Highland.
You're muted.
Aye.
Member Highland, aye. Chair Wolf.
Aye.
Chair Wolf, aye. So, I want to make sure, so now that we have an amendment to the motion.
So did it pass? Did it pass?
Yes, it did.
Okay. For the
Yeah.
record, the motion passed.
The motion passed, yes. I apologize. So,
Excuse me.
let me read the motion now that we have an amendment. So it would be to move to amend the original motion to continue to allow the respondent to perform a signal search within the next 7 days and to provide confirmation of the results of that search to the task force. This issue will be honored by the Compliance and Amendments Committee at their next meeting. And in addition, the task force is making an amendment to request a response on the signal search. You're gonna have to say it again, Lila, because I don't think I have it right.
It's not. Go ahead. You don't have to say amendment. It's just part of the motion.
We're
Go ahead.
also we're requesting a response to the question as to whether a signal search was conducted when the sunshine request was first made.
All right. In addition to requesting a response to the question on whether a signal search was to inquire when the signal search was originally performed, is that it?
No, whether a signal search was performed in response to the original request. And and if so, yeah, we want to know if it has already happened.
Yeah.
Yeah.
Yeah. Okay. Gotcha. So we're good?
Mm-hmm.
Yes. Okay. So now discussion on the main motion. Hearing none. Any public comment on the main motion?
Yes, please.
Wait for Mr. Leger.
So are you ready?
Yeah.
Okay. Go ahead.
Thank you. I think the clarification that member, I believe it was LaHood, said is very important, because if something is not searched at the time of the original request, auto destruction can easily destroy it, and then they can just make the record. So it's very important about whether they did the search at the time of the original request,
Any other public comment?
Yeah, I have another public comment.
Go ahead, speaker.
Yeah, so I'm wondering, even if messages were deleted on Mr. Budin's device, is it possible that messages could be retrieved from the devices of the individuals whom he was communicating with? And if so, would there be some sort of mechanism for that under records request laws?
Any other public comment? Okay, hearing no public comment, more public comment. Public comment is closed. Are we ready for a vote? Hearing no objections, please call the roll.
I'm sorry. Member LaHood?
Aye.
Member LaHood, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Frazier?
Aye.
Member Frazier, aye. Member Padmanabhan?
Aye.
Padmanabhan, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Member Stein?
Aye.
Member Stein, aye. Member Forsley?
Aye.
Member Forsley, aye. Member Schmidt?
Could I get clarification? Is this the LaHood motion, member LaHood amendment?
Yes.
Oh, I thought, okay. I thought.
No. Let me clarify for you. This is the Vice Chair Yankee amendment to continue. And then there was an amendment that became now the main motion. Then member LaHood made an amendment, an additional amendment with regards to the search of the Signal app.
And that's what this vote is on.
No, we already voted. That was the last vote. That last vote was approved.
Okay.
So now the main motion is both together.
It's a, okay, is this the motion brought by member Padmanabhan that
No.
we're on?
No,
Okay, we
the
haven't
vote-
gotten to that one yet.
Yeah, no. The motion by member Padmanabhan was replaced by Vice Chair Yankee's amendment. He made an amendment to replace the entire motion. Okay, that was approved. We all approved it. And then once that was approved, and now it became the main motion, member LaHood made an additional amendment on top of the continuance that there should be an additional search of the Signal app. Okay, and we just voted on that. That was approved. So now we're at the main motion now with the two amendments. So now the main motion on the floor is to continue the item, and that the respondent should perform the search and produce any additional documents within 7 days, notify that they've done that to the petitioner and the Sunshine Task Force, and in addition to search the Signal app.
Okay, thank you for that clarification. My vote is then aye.
Okay, continue with the vote, please.
Okay. Member Wong?
Aye.
Member Wong, aye. Member Highland?
Aye.
Member Highland, aye. Member Chair Wolf?
Aye.
Chair Wolf, aye. All right, let's see. Member Yankee moved to amend the original motion to continue.
What's the tally of the vote, please?
All right, it's passed.
Okay, thank you.
All right.
All right, let's thank you, parties, for attending. Let's move on to our next agenda item.
Item number 8, file number 20092, complaint filed by Carl Kramer against the Department of Recreation and Parks for allegedly violating Administrative Code Section 6721 by failing to respond to a records request in a timely and or complete manner.
You told us that that was pulled.
Yes, exactly. Yesterday afternoon at about 3:20.
Okay, so we've already done that at the top of the meeting. So let's move to item number 9.
All right. Item number 9, Sunshine Ordinance Task Force, election of officers.
Okay, members, this is our once a year election of officers. We have just 2 officers. They're the chair and the vice chair. If you're curious as to how the committee chairs get chosen, generally that is discussed with the chair. The chair will make those nominations, and generally they're affirmed by the task force at a subsequent meeting. If there is no changes, then there's no changes, and everybody can remain where they are. But this is an opportunity to kind of move the deck chairs around. I do want to kind of present a proposal. And before I ask for nominations, a proposal that I and Vice Chair Yankee have been talking about, which can of course be countered by any nominations for the positions, which will take one officer position at a time. We would like to propose that both of us be reelected, and for anyone who is interested to shadow us. We're suggesting this because there are several operations in process that we're deeply involved in as officers, in addition to the current backlog and developing a smooth transition for all of us, including staff. Jumping into the fire or running through a gauntlet, we feel would not be conducive for the flow, and that is current and evolving. For anyone or more of you that would be shadowing us, if we all agree that you feel comfortable to start assuming those positions, we'll then agendize the elections again and reopen them and implement this process again. Like I said, doesn't obfuscate anyone who wants to step up now and to either nominate someone or nominate yourself. So the floor is open for nominations. Member Neighbors.
In the interest of gender balance, I would like to nominate Member LaHood. I believe she has a lot of experience. She's chaired my committee I sit on with finesse and mastery of parliamentary procedure. I think all of us benefit from having leadership from a woman on any committee, but particularly this one, because it's been a while since a woman has led the committee, and we have someone who is very experienced to do that. So that's my nomination.
Member LaHood, do you accept the nomination?
First of all, I want to say thank you. I am flattered. Is the nomination a nomination to shadow or a nomination for the role?
I think Member Neighbors was suggesting for the role.
It's for the role.
First of all, I want to say thank you, and I really appreciate the nomination, but I do not think that I can accept it in good conscience, even though